The Clinton sock drawer case is the governing case, I would argue, in terms of explaining what Trump did and how it should be analyzed. And many years ago, Judicial Watch, I guess it's 10, 12 years ago now, we had sought records of the Clinton tapes. These were tapes that Clinton had that were given to him of his working as president. So they were presidential tapes, right? Now, he was talking to a foreign leader, he was talking to members of Congress, all sorts of things that presidents do and would be typically presidential records if they were analyzed. But he kept them, right? And we thought they should be taken by the archives. And they told us, no, you can't second guess. And so this is how I described it. And I'm going to give you a fuller recitation of this because I think it's important. This is an historic piece of, this is an infamous but historic indictment. So I want you to know just how dishonest it is because it doesn't mention any of this in the indictment, by the way. The Presidential Records Act, the Constitution's, the President's prerogatives under the Constitution, etc. The Clinton sock drawer case, litigated by Judicial Watch, shows how the Justice Department and the National Archives did an about-face and ignored precedent and their own prior legal positions in targeting Trump over records that he had an unconditional right to have under the Presidential Records Act and the U.S. Constitution. And this is what I had tweeted out. In 2010, Judicial Watch submitted a Freedom of Information Act request to the Clinton Library and Presidential Museum, seeking access to these Clinton audio tapes that I talked about from his time as president. The Obama National Archives, NARA, it's called NARA, National Archives, responded that the audio tapes are personal records and therefore not subject to the Presidential Records Act or FOIA. So what happens is under the Presidential Records Act, the archives takes custody of records designated as presidential records by a president or people that he designates to designate as president to do that work. And then they make them available after a certain period of time under FOIA or the FOIA equivalent under the Presidential Records Act, meaning you can ask for them, and if you don't get them, you can sue. Judicial Watch subsequently sued, as I noted, and requested that the court declare the audio tapes to be presidential records, and because they are not currently in the government's possession, to compel the archives to assume custody and control over them. Doesn't that sound exactly like the Trump case? We took the Justice Department position they're now taking against Trump, against Clinton, and they opposed us. Judge Amy Berman Jackson, who is far, far to the left on the judiciary. She's in the U.S. District Court here in the District of Columbia, so she's a D.C. judge, ruled against us. And in doing so, she explained, and I'm going to quote from the court opinion. Under the statutory scheme established by the Presidential Records Act, the decision to segregate personal materials from presidential records is made by the president during the president's term and in his sole discretion. And then she quotes the law, she gives a citation to the law. If you want to look it up, it's 4 U.S.C. section 2203B. So the archives could not make a classification decision different from the president. I'll say it again. The archives could not make a classification decision different from the president. Since the president is completely entrusted with the management and even the disposal of presidential records during his time in office, it would be difficult for this court to conclude that Congress intended that he would have had less authority to do what he pleases with what he considers to be his personal records. The Presidential Records Act contains no provision obligating or even permitting the archivist excuse me, I lost my time. I lost my place. I'll start over again. The Presidential Records Act contains no provision obligating or even permitting the archivist to assume control over records that the president categorized and filed separately as personal records. At the conclusion of the president's term, the archivist only assumes responsibility for the presidential records. So that's where the archivist's role ends. Plaintiff contends that its factual allegations about the nature and substance of the audio tapes clearly establishes them to be presidential records, regardless of how they were treated by President Clinton. Well, the court is not so sure. But even if the court were inclined to agree with the plaintiff's reassessment of President Clinton's decision, it would not alter the conclusion that the injury cannot be redressed. The Presidential Records Act does not confer any mandatory or discretionary authority on the archivist to classify records. Under the statute, this responsibility is left solely to the president. While the plaintiff casts this lawsuit as a challenge to a decision made by the National Archives, the Presidential Records Act makes it clear that this is not a decision the archivist can make. And in this particular case, this is not a decision the archivist did make because President Clinton's term ended in 2000, and the tapes were not provided to the archives at that time. He kept them, so there's nothing anyone can do. So this is the background on that case. So when in office, President Clinton enlisted Taylor Branch, who is an historian, to assist him in creating an oral history of his 8 years in office by recording 79 audio tapes that preserve not only President Clinton's thoughts and commentary on contemporaneous events and issues he was facing as president, but in some instances recorded actual events such as presidential conversations. For example, the audio tapes contain the following content. President Clinton contemplating potential changes to his cabinet, including whether to fire the CIA director and whether to nominate Madeleine Albright for the Secretary of State. President Clinton's thoughts and reasoning behind foreign policy decisions such as the United States military involvement in Haiti and the contemplated relaxation of the United States embargo of Cuba. Typically classified, right? Certainly national defense information, which is the new hip phrase. President Clinton's side of telephone conversations with foreign leaders, members of the United States Senate and cabinet secretaries. President Clinton speaking to several members of the United States Senate in which President Clinton attempted to persuade the senators to vote against a specific amendment before the Senate. President Clinton's side of a telephone conversation with Congressman William Natcher of Kentucky, in which President Clinton explained his reasoning for entering into NAFTA, the North American Free Trade Agreement, based on technical forecasts that he received during presidential briefings. And President Clinton's side of a telephone conversation with the U.S. Secretary of State, Warren Christopher, who was Secretary of State at the time, concerning a diplomatic impasse over Bosnia. I mean, that was like a war in some, well, I guess it was, depending on when it took place. That was one of Clinton's wars. President Clinton took these audio tapes with him when he left office. He did not turn them over to the National Archives and Records Administration. So, as I note in this description, any indictment alleging unlawful retention of classified or national defense information is at odds with the Presidential Records Act, court precedent, and prior DOJ position and archives position on presidential prerogatives on records. So there's no there. They allege he had records he wasn't supposed to have, when in fact he did have records he was allowed to have, and they were personal to him. And I've reviewed the indictment, and this is my conclusion about the indictment. And I'm going to give it to you in writing, because I think it's important. Of course, the left went crazy when I put this out there, because they only have one way of thinking about this. It's always get Trump, right? The rule of law be danged. I've carefully reviewed the indictment, everyone. And it was an indictment, as I will note, by his political opponents at the Biden Justice Department. And as I've noted, Judicial Watch has over 30 years experience, or nearly 30 years experience, litigating federal and presidential records cases, including, as I noted, the Clinton sock drawer case, which is really, in many ways, the governing analysis here. The document the indictment, dishonestly ignores the U.S. Constitution, the Presidential Records Act, legal precedent, and the DOJ's archives' previous position that White House records a president takes with him when he leaves the White House are presumptively personal and not subject to review by partisan Biden appointees at DOJ or archives. Under the Constitution, federal law, and precedent, none of the documents are currently classified or national defense information that restricts Trump's handling of them. They are all his personal records and frankly should be returned to him. If justice prevails, this indictment won't survive scrutiny by honest constitutionalist judges and will be thrown out. So I looked at this indictment, as I note in this statement, And what they ignore is that the president had rights to these documents. They say there are recordations in 2021 where he suggests, well, this is still classified. Well, he was wrong. It wasn't classified because he had it. He took it with him. It became personal. I mean, how do I know that? Because in one of the court hearings related to this Clinton Soccer case, Justice Department took the position that if the president has records after he leaves office, they're presumptively personal. Except if you're Trump, right?